About the case of Pearl and Dean Philippines Incorporated versus Shoemart Incorporated and North EDSA Marketing Incorporated, GR number 148222, August 15, 2003, penned by Corona Ajay. So in this case, no, we'll be able to differentiate between copyrights, patents, and trademarks. Just to give you an overview, the trademark, copyright, and patents are different intellectual property rights that cannot be interchanged with one another. We have to take note of that. A trademark is a very visible sign. No? So it's a sign capable of distinguishing the goods, trademark, or services of an enterprise and shall include a stamp or a mark container of goods. In relation thereto, a trade here name means the name or designation identifying or distinguishing an enterprise. So on the other hand, if you say it's a trade, the trade name again is a means to the name or designation identifying the enterprise. Meanwhile, the scope of copyright is confined to literary and artistic works. So copyright on the other hand deals with literary and artistic works, which are originally intellectual creations in the literary and artistic domain, protected from the moment of their creation. Now, how about the patentable inventions or the patent? The patent, on the other hand, refer to any technical solution of a problem in any field of human activity in which is new, involves an inventive step, and is industrially applicable. Okay, so we will now talk about the case of Pearl and Dean versus Shoemart Incorporated and the North EDSA Marketing Incorporated. In the instant petition for review on certiorari under Rule 45, the Rules of Court, petition Pearl and Dean assails on May 22, 2001, the decision of the Court of Appeals reversing the October 31, 1996 decision of the Regional Trial Court. No, so they try to assail the decision of the Court of Appeals, which the Court of Appeals on October 31, 1996, decided by the RTC of Makati, Branch 123 in civil case number 92516, which declared the private respondent Shoemart or SM Incorporated and North EDSA Marketing Incorporated liable for infringement of trademark and copyright and unfair competition. So the RTC here originally declared them guilty of infringement of trademark and copyright. However, the Court of Appeals reversed such decision, and that's why the ones that were accused here for infringement and trademark appealed to the Supreme Court to assail the decision. So what were the factual incidents or the factual antecedents? On May 22, 2001, decision of the Court of Appeals contained a summary of this dispute. We have the plaintiff appellant Pearl and Dean Incorporated or Philippines, is a corporation engaged in the manufacture of advertising display units simply referred to as light boxes. These units utilize special printed posters sandwiched between plastic sheets. So it's like what we see right now in advertisement, wherein it will light up, and it will display the company, and illuminated with backlights. So there are backlights. Pearl and Dean was able to secure a certificate of copyright registration dated January 20, 1981 over these illuminated display units. The advertising light boxes were marketed under the trademark poster ads. The application for registration of trademark was filed with the Bureau of Patents, Trademarks, and Technology Transfer on June 20, 1983, but was approved only on September 12, 1988 per registration number 41165. From 1981 to about 1988, Pearl and Dean employed the services of Metro Industrial Services to manufacture its advertising displays. Sometime in 1985, the Pearl and Dean negotiated with the defendant appellant Shoemart or SM for the lease and installation of the light boxes in SM City North EDSA, since SM North EDSA was still under construction. So at that time, SM offered an alternative. He said that since SM Makati and SM Cubao, to which they referred them to SM Makati and SM Cubao, no, to which Pearl and Dean agreed also. Now, on September 11, 1985, Pearl and Dean's general manager in the name of Rodolfo Vergara submitted for signature the contracts covering SM Cubao and SM Makati to SMI's Advertising Promotions and Publicity Division Manager. Only the contract for SM Makati, however, was returned signed. On October 4, 1985, Vergara wrote Abano inquiring about the other contract and reminding him that their agreement for installation of light boxes was not only for its SM Makati branch, but also remember it's for SM Cubao also. So SMI did not bother to reply. Instead, in a letter dated January 14, 1986, SM House Counsel, no, the lawyer for SM, they informed Pearl and Dean that it was rescinding the contract for SM Makati due to non-performance of the terms thereof. Now, in his reply, dated January 17, 1986, Vergara protested the unilateral action of SMI, saying it was without basis. In the same letter, he pushed for signing of the contract of SM Cubao. 2 years later, Metro Industrial Services, the company formerly contracted by Pearl and Dean to fabricate its display units, offered to construct light boxes for Sumar's chain of stores. So SMI approved the proposal, and 10 light boxes were subsequently fabricated by the Metro Industrial for SMI. So basically, Metro Industrial was capable now of producing the same product of Pearl and Dean. And they even engaged the services of EYD Rainbow Advertising Corporation to make the light boxes. So worse, they were asked to create 300 units fabricated in 1991, and these were delivered on a staggered basis and installed at SM Mega Mall and SM City. Sometime in 1989, Pearl and Dean received reports that exact copies of its light boxes were installed at SM City and in the fast food section of SM Cubao. Upon investigation, Pearl and Dean found out that aside from the 2 reported SM branches, light boxes similar to those in manufacturers were also installed in 2 other SM stores. It further discovered that the defendant appellant North EDSA Marketing, through its marketing arm, Prime Spots Marketing Services, was set up primarily to sell advertising space in lighted display units located in SMI's different branches. So Pearl and Dean noted that the North EDSA Marketing Incorporated, or NEMI, is a sister company of SMI. In the light of its discoveries, Pearl and Dean sent a letter dated December 11, 1981 to both SMI and NEMI, enjoining them to cease using the subject light boxes and to remove the same from SMI's establishment. It also demanded the discontinued use of the trademark poster ads and the payment of Pearl and Dean of compensatory damages amounting to 20 million. Upon receipt of the demand, SMI suspended the leasing of 224 light boxes, and NEMI took down its advertisements or poster ads from the lighted display in SMI stores, claiming that both SM and NEMI failed to meet all its demands. Pearl and Dean filed this instant case of infringement of trademark and copyright, unfair competition, and damages. In denying the charges hurled against it, SM maintained that it independently developed its poster panels using commonly known techniques and available technology without notice of reference to Pearl and Dean's copyright. SMI noted that the registration of the marked poster ads was only for stationaries, such as letterheads, envelopes, and the like. Besides, according to SMI, the word poster ads is a generic term, which cannot be appropriated as trademark, and as such, the registration of such mark is invalid. It also stressed that the Pearl and Dean is not entitled to the relief prayed for in its complaint, since its advertising display units contained no copyright notice, in violation of Section 27 of Presidential Decree Number 49. So SMI alleged that Pearl and Dean had no cause of action against it, and the suit was purely intended to malign SMI's good name. On this basis, SMI, aside from praying for the dismissal of the case, also counterclaimed for moral and actual and exemplary damages and for the cancellation of Pearl and Dean's certification of copyright registration number PDR 2558 dated January 20, 1981, and the certificate of trademark registration number 4165 dated September 12, 1988. NEMI, no, for its part, denied having manufactured, installed, or used any of the advertising display units, nor having engaged in the business of advertising. It pleaded they actually pleaded, NEMI pleaded that they haven't really engaged in business in advertising, admission and denials, and prayed for similar reliefs and counterclaims as SMI. So the RTC of Makati decided in favor of Pearl and Dean. So they favored Pearl and Dean. So they decided that they were guilty of infringement of copyright and a violation of law. Wherefore, defendants SM and NEMI are found jointly and severally liable for infringement of copyright under Section 2 of Presidential Decree 49 as amended, and infringement of trademark under Section 22 of RA 166 as amended, and hereby penalize under Section 28 of PD 49 amended, and Sections 23 and 24 of RA 166 as amended. Accordingly, defendants are hereby directed, you are to pay actual damages of 16,600,000 pesos and 600,000 pesos. You should pay moral damages of 1 million pesos, exemplary damages of another 1 million pesos, and attorney's fees of 1 million pesos, and cost of suit. To deliver under oath for impounding in the National Library all light boxes of SMI, which were fabricated by Metro Industrial Services and EYD Rainbow Advertising Corporation, and to deliver under oath to the National Library all filler posters using the trademark poster ads for destruction, and permanently refrain from infringing the copyright of the plaintiff's light boxes and its trademark poster ads. Defendants' counterclaims are hereby ordered dismissed for lack of merit. So they appealed not to the Court of Appeals, but the Court of Appeals reversed the trial court's decision. Since the light boxes cannot by any stretch of imagination be considered as either prints and pictorial illustrations, advertising, copies, labels, tags, or box wraps to be properly classified as copyrightable class or work, we have to agree with the SMI when it posited that what was copyrighted were the technical drawings only and not the light boxes themselves. Thus, when a drawing is technical and depicts a utilitarian object, a copyright over the drawings like the plaintiff's will not extend to the actual object. It has so been held under jurisprudence, of which the leading case is Baker versus Selden. So the basis of the Court of Appeals here is Baker versus Selden, in US. In that case, Selden have obtained a copyright protection of the book entitled Selden's Condensed Ledger or Bookkeeping Simplified, which purported to explain a new system of bookkeeping, including as part of the book were blank forms and illustrations consisting of ruled lines and headings, specifically designed for use in connection with the system explained in the work. So these forms showed the entire operation of a day or a week or a month, or a single page or two pages following each other. The defendant Baker then produced forms which were similar to the forms illustrated by Selden's copyrighted. So it was Selden who was the original author. The court held that exclusivity to the actual form is not extended by a copyright. So even if it's your idea, it's in the book, it's not it doesn't extend to the actual work. The reason was that to grant a monopoly of the underlying art when no examination of its novelty has ever been made would be a surprise and a fraud upon the public, and that is the province of letters patent, not of copyright. So it should be a patent that should be issued and not a copyright. And that is precisely the point. No doubt aware that its alleged original design would never pass the rigorous examination of patent application, plaintiff appellant fought to foist a fraudulent monopoly in the public by conveniently resorting to copyright registration, which merely employs a recordal system without the benefit of in-depth examination of novelty. The principle in Baker versus Selden was likewise applied in Mueller versus Triborough Bridge Authority. In this case, Mueller had obtained a copyright over an unpublished drawing entitled Bridge Approach. The drawing showed a novel bridge approach to unsnarl traffic congestion, and the defendant constructed a bridge approach which was alleged to be an infringement of the new design illustrated in the plaintiff's drawing. In this case, it was held that the protection of the drawing was not extended to the unauthorized duplication of the object drawn, because the copyright extends only to the description or the expression of the object, not to the object itself, and it does not prevent one from using the drawings to construct the object portrayed in the drawing. So basically, in the case of Baker versus Selden, it's all about the form. In Mueller versus Triborough Bridge Authority, it was more of a technical drawing of a bridge, and then it says here that the protection could not be extended to the actual thing, but only to the expression of such idea as expressed in the technical drawings. Okay, so in fine, we cannot find in two other cases like Imperial Homes Corp and Lamont and Scholz Homes and Maddox, it was held that there is no copyright infringement when one who, without being authorized, uses a copyrighted architectural plan to construct a structure. This is because the copyright does not extend to the structure themselves. In fine, we cannot find SMI liable for infringing the Pearl and Dean's copyright over the technical drawings of the latter's advertising display units. The Supreme Court trenchantly held in Faberge Incorporated and Intermediate Appellate Court that the protective mantle of trademark law extends only to the goods used first user as specified in the certificate of registration, following the clear mandate conveyed under Section 20 Republic Act 166 as amended, otherwise known as the trademark law, which reads, certification of registration prima facie evidence of validity. A certificate of registration on a mark or a trade name shall be a prima facie evidence of the validity of the registration, the registrant's ownership, the mark or trade name, of the registrant's exclusive right to use the same in connection with the goods, businesses, and services specified in the certificate, subject to any conditions and limitations stated therein. So the records show that on June 20, 1983, Pearl and Dean applied for registration of the trademark poster ads with the Bureau of Patents, Trademarks, and Technology Transfer. Said trademark was recorded in the principal register on September 12, 1988. Under registration number 41165, covering the following products: stationery such as letterheads, envelopes, calling cards, and newsletters. So take note of this, because their trademark is only for stationery such as letterheads, envelopes, calling cards, and newsletters, and not for advertisement. With this as a factual backdrop, we see no legal basis to finding the liability on the part of the defendants for their use of the words poster ads in advertising display units in suit. Jurisprudence has interpreted Section 2 of the trademark law as an implicit permission to a manufacturer to venture into the production of goods and allow the producer to appropriate the brand name of the senior registrant and goods other than those stated in the certificate of registration. So what is stated in the certificate of registration, that is what is protected. Now, the Supreme Court further emphasized the restrictive meaning of Section 20 when it's stated through Justice Conrado versus Sanchez. Really, if the certificate of registration were to be deemed as including goods not specified therein, then a situation may arise whereby an applicant may be tempted to register a trademark on any and all goods which his mind may conceive, even if he had never intended to use the trademark to the said goods. We believe that such omnibus registration is not contemplated by our trademark law. While we do not discount the striking similarity between Pearl and Dean's registered trademark and the defendant's appellant's poster ads design, as well as the parallel use of such words in the parties' respective advertising copies, we cannot find the defendant appellants liable for infringement of trademark. Poster ads was registered by Pearl and Dean for specific use in its stationaries. In contrast to the defendant's appellants who use the same words in advertising display units. So for Pearl and Dean, what is protected is their use of that trademark in stationaries. But what the defendant and appellants have is only for display units. So there's no infringement of their trademark. Why Pearl and Dean limited the use of trademark to stationaries is simply beyond us, but having already done so, it must stand by the consequence of the registration which it had caused. We are constrained to adopt the view of the defendant's appellants. The words poster ads are simple contraction of the generic term poster advertising. In the absence of a convincing proof that the poster ads had acquired a secondary meaning in this jurisdiction, we find that the Pearl and Dean's exclusive right to use the poster ads is limited to what is written in a certificate of registration, namely stationaries. Defendants' appellants cannot thus be held liable for infringement of the trademark poster ads. There being no finding of either copyright or trademark infringement on the part of SMI and NEMI, the monetary award granted by the lower court to Pearl and Dean has no leg to stand on. Wherefore, premises considered, the assailed decision is reversed and set aside, and another is rendered dismissing the complaint and counterclaims in the above case for lack of merit. So we see here a very detailed decision from the Court of Appeals. But they were dissatisfied with the decision, so the Pearl and Dean filed an instant case. He is now the petitioner in the Supreme Court, and he wants to question all this. The Honorable Court of Appeals, according to the Pearl and Dean, is in ruling that no copyright infringement was committed by respondents. They erred in ruling that there was no copyright infringement committed by the respondents, and that the Honorable Court of Appeals erred ruling that no infringement of Pearl and Dean's trademark poster ads was committed. And again, the Court of Appeals erred in dismissing the award of the trial court despite the latter's finding, not disputed by the Honorable Court of Appeals, that SM was guilty of bad faith in its negotiation and advertising contracts with Pearl and Dean, and the Honorable Court of Appeals erred in not holding respondents SM and NEMI liable to Pearl and Dean for actual moral and exemplary damages, attorney's fees, and cost of suit. In resolving this very interesting case, we are challenged once again to put into proper perspective four main concerns of intellectual property. First is that we should focus on the following issues. If the engineering or technical drawings of an advertising display unit are granted copyright protection by the National Library, is the light box depicted in such engineering drawings right there and then also protected by such copyright? No? So or should the light box be registered separately and protected by a patent issued by the Bureau of Patents, Trademarks, and Technology Transfer, now Intellectual Property Office, in addition to the copyright of the engineering drawings? Can the owner of the registered trademark legally prevent others from using such trademark if it is a mere abbreviation of the term descriptive of his goods and services or business? So we have a third issue here. Can the owner of a registered trademark legally prevent others using trademark if it is a mere abbreviation of the descriptive of his goods, services, or business? So let's start with the issue of copyright infringement. So Pearl and Dean's complaint was that SM infringed on its copyright over the light boxes when SM had the units manufactured by Metro and EYD Rainbow advertising for its own account. Obviously, the petitioner's position was premised on its belief that its copyright over the engineering drawings extended ipso facto to the light boxes depicted or illustrated in the said drawings. In ruling there was no copyright infringement, the Court of Appeals held that the copyright was limited to the drawings alone and not to the light box itself. We agree with the appellate court. First, the petitioner's application for copyright certificate as well as copyright certificate PD R2588 issued by the National clearly stated that it was for a Class O work on PD 49, which was a statute then prevailing. Said Section 2 expressly enumerated the works subject to copyright. The rights granted by this decree shall from the moment of creation subsist with respect to any of the following works: prints, pictorial illustration, advertising copies, labels, tags, and box wraps. Although the petitioner's copyright certificate was entitled Advertising Display Units, which depicted the box type, its claim for copyright infringement cannot be sustained. Copyright in the strict sense of term is purely a statutory right. By being a mere statutory grant, the rights are limited to what the statute confers. It may be obtained and enjoyed only with respect to the subjects and by the person and on the terms and conditions specified in the statute. Accordingly, it can cover only the works falling within the statutory enumeration of the description. So Pearl and Dean secured its copyright under the classification Class O work. So, unsa man ning Class O? Class O provides that this includes prints, pictorial illustration, advertising copies, labels, tags, and box wraps. No? This being so, petitioner's copyright protection extended only to the technical drawings and not to the light box itself, because the latter was not at all in the category of prints, pictorial illustration, advertising copies, labels, tags, and box wraps. Stated otherwise, even as we find that PD Pearl and Dean indeed owned a valid copyright, the same could have referred only to the technical drawings within the category of pictorial illustrations. It could not have possibly stretched out to include the underlying lightbox. The strict application of the law's enumeration section 2 prevents us from giving petitioner even a little leeway, that is, even if its copyright certificate was entitled advertising display units. What the law does not include, it excludes, and for the good reason. The lightbox was not a literary or an artistic piece which could be copyrighted under the copyright law, and no less clearly, neither could be the lack of statutory authority to make the lightbox copyrightable be remedied by simplistic act of entitling copyright certificate issued by the National Library as advertising display units. In fine, SM and NEMI reprinted Pearl and Dean's technical drawings for sale to the public without license from PD, then no doubt they would have been guilty of copyright infringement. But this is not the case. So what is stated here, if SM and NEMI sold the technical drawing, no, that's another story. So SMI and NEMI's act complained by PD were to have the unit similar, identical to the lightbox illustrated in technical drawings, was manufactured by Metro and EYD Rainbow Advertising for leasing out of different advertisers. Was this an infringement of petitioner's copyright over the technical drawings? We do not think so. During the trial, the president of the Pearl and Dean himself admitted that the lightbox was neither a literary nor an artistic work, but an engineering or marketing invention. Obviously, there appeared to be some confusion regarding what ought or not ought to be the proper subjects of copyright, patents, and trademarks. In the leading case of Co versus Court of Appeals, we ruled that these three legal rights are completely distinct and separate from each other, and the protection afforded by one cannot be used interchangeably to cover items or works that exclusively pertain to the other. For example, trademark, copyright, and patents are different intellectual property rights. So it's said here they are different from each other. They cannot be interchanged with one another. A trademark is a visible sign capable of distinguishing goods, trademark, or services of an enterprise, and shall include a stamp or a mark container of goods. In relation thereto, a trade name means the name or designation identifying or distinguishing an enterprise. Meanwhile, here we see that a trademark, visible sign siya, no, for you to distinguish a particular enterprise. The trade name means the name or designation identifying or distinguishing the enterprise. So, trade name, no, so you have a trade name. Meanwhile, the scope of the copyright is confined on literary and artistic works, which are original intellectual creations of literary and artistic domain, protected from the moment of their creation. So, patentable inventions, on the other hand, refer to technical solution of a problem in any field of human activity, which is new, involves an inventive step, and it's industrially applicable. It involves an inventive step, and it's industrially applicable. So, that's for patentable invention. It's really a technical solution of a problem of any human activity. On the issue of patent infringement, this brings us to the next point. Despite its manufacture and commercial use of light boxes without license from the petitioner, private respondents cannot be held legally liable for infringement of PD's copyright over its technical drawings on the light boxes. Should they be liable instead for infringement of patent? We did not think so either. For some reason or another, petitioner never secured a patent for the light boxes. It is therefore acquired no patent rights which could have protected by its invention. In fact, it really was, and because it has no patent, petitioner could not legally prevent anyone from manufacturing or commercially using the contraption. In Chrysler Precision Systems Incorporated, we held that there was no infringement of a patent until a patent has been issued, since whatever right one has to the invention covered by the patent arises alone from the grant of a patent. An inventor has no common law right to a monopoly of his invention. He has the right to make use and vend his invention, but if voluntarily discloses it, such as by offering it for sale, the world is free to copy and use it with impunity. A patent, however, gives the inventor the right to exclude all others. As a patentee, he has the exclusive right of making, selling, or using the invention. Making, selling, and using the invention. On the assumption of the petitioner's advertising units were patentable invention, petitioner revealed them fully to the public by submitting the engineering drawings thereof to the National Library. To be able to effectively and legally preclude others from copying and profiting from the invention, a patent is a primordial requirement. No patent, no protection. The ultimate goal of the patent system is to bring new designs and technologies into the public domain through disclosure. Ideas once disclosed to the public without the protection of a valid patent are subject to the appropriation without significant restraint. One side of the coin, is the public, which will benefit from new ideas, are the inventors who must be protected. As held in Bauer Tsai versus Donnell, the act secured to the inventor an exclusive right to make use and vend the thing patented, and consequently to prevent others from exercising like privileges without the consent of the patentee. It was passed for the purpose of encouraging useful invention and promoting new and useful inventions by the protection and stimulation given to an inventive genius, and was intended to secure to the public, after the lapse of exclusive privileges granted, the benefit of such improvements and inventions. The law attempts to strike an ideal balance between two interests. No? The patent system thus embodies a carefully crafted bargain for encouraging the creation and disclosure of a new useful and non-obvious advances in technology design. In return for the exclusive right to practice the invention for a number of years, the inventor may keep his invention and reap the fruits indefinitely. In consideration of its disclosure and the consequent benefit to the community, the patent is granted. The exclusive enjoyment is guaranteed for him for the next 17 years. But upon the expiration of that period, the knowledge of the invention inures to the people, who are thus enabled to practice it and profit by its use. The patent law was threefold purpose. First, patent law seeks to foster and reward invention. Second, it promotes disclosure of inventions to stimulate further innovation and to permit the public to practice the invention once the patent expires. And third, the stringent requirements for patent protection to seek to ensure that the ideas of the public domain remain there for free use in the public. It is only after an exhaustive examination of the patent office that the patent is issued. Such an in-depth investigation is required because, in rewarding a useful invention, the rights and welfare of the community must be fairly dealt with and effectively guarded. To that end, the prerequisites to obtaining a patent is strictly observed, and when a patent is issued, the limitations on its exercise are equally strictly enforced. To begin with, a genuine invention of discovery must be demonstrated, lest in the constant demand for new appliances, the heavy hand of tribute to be laid on each slight technological advance in art. There is no such scrutiny, in the case of copyrights, nor any notice published before its grant to the effect that the person is claiming the creation of a work. The law confers copyright from the moment of creation, and the copyright certificate is issued upon registration with the National Library of a sworn ex parte claim of creation. Therefore, not having gone through the arduous examination of patents, the petitioner cannot exclude others from the manufacture, sale, or commercial use of the light boxes in the sole basis of its copyright certificate over technical drawings. Stated otherwise, the petitioner seeks exclusively without an opportunity for the patent office to scrutinize the light box eligibility as a patentable invention. The irony here is that the petitioner secured a patent. Instead, its exclusivity would have been for 17 years only, but through the simplified procedure of copyright registration with the National Library, without undergoing the rigors of defending the patentability of its invention before the IPO, the petitioner would be protected for 50 years. This situation could not have been the intention of law. In the cited case of Baker versus Selden, the United States Supreme Court held that only the expression of idea is protected by copyright and not the idea itself. In that case, the plaintiff held the copyright of the book, which expounded on the new accounting system he had developed. The publication illustrated blank form ledgers utilized in such system. The defendant reproduced forms similar to those illustrated in the plaintiff's copyrighted book. The U.S. Supreme Court ruled that there is no doubt that a work on the subject of bookkeeping, though only explanatory of well-known systems, may be the subject of a copyright, but then it is claimed only as a book. But there is a clear distinction between books such as and the art which is intended to illustrate. The mere statement of the proposition is so evident that it requires hardly an argument to support it. The same distinction may be predicated of every other art as well as that of bookkeeping. A treatise on the composition and the use of medicines, be they old or new, or the construction of the use of plows or watches or churns, on the mixture of application of colors for painting and dyeing, on the mode of drawing lines to produce the effect of perspective, would be the subject of copyright. But no one would contend that the copyright of the treatise would give the exclusive right the art of the manufacturer described therein. The copyright of the book, if not pirated from other works, would be valid without regard to the novelty or want of novelty for its subject. The novelty of the art or thing described or explained has nothing to do with the validity of the copyright. To give to the author the book an exclusive property in the art described therein, when no examination of its novelty has ever been officially made, would be a surprise and a fraud upon the public. That is the province of letters patent and not of copyright. The claim to an invention or discovery of an art manufacture must be subjected to the examination of the patent office before an exclusive right therein can be obtained, and a patent from the government can only secure it. The difference between the two things, letters, patent, and copyright, may be illustrated by a reference to the subjects just enumerated. Take the case of medicines. Certain mixtures are found to be of great value in the healing art. And if the discoverer writes and publishes a book on the subject as regular physicians do, he gains no exclusive right to the manufacture and sale of the medicine. He gives that to the public. If he desires to acquire such exclusive right, he must obtain a patent for the mixture as a new art, manufacture, or composition of matter. He may copyright his book if he pleases, but that only secures him the exclusive right for printing and publishing the book. So what is protected in a copyright is printing and publishing a book. So of all other inventions or discoveries, the copyright of a book on perspective, no matter how many drawings, illustrations it may contain, gives no exclusive right to the modes of drawing described, although they may never have been known or used before. By publishing the book without getting a patent for the art, and the latter is given to the public. Now, whilst no one has the right to print or publish his book or any material part or thereof as a book intended to convey instruction in the art, any person may practice and use the art itself, which he has described and is illustrated therein. The use of the art is totally different thing from the publication of the book and explaining it. The copyright of a book on a bookkeeping cannot secure the exclusive right to make, sell, and use the account books prepared upon the plan set forth in such book. Whether the art might or might not have been patented is a question which is not before us. It was not patented and is open and free to use by the public. And of course, in using the art, the ruled lines and headings of accounts must necessarily be used as incident to it. The plausibility of the claim put forward by the complainant in this case arises from a confusion of ideas produced by the peculiar nature of the art described in the books, which have been made the subject of the copyright. In describing the art, the illustration and diagrams employed happened to correspond more closely than usual with the actual work performed by the operator who uses the art. The description of the art in a book, though entitled to the benefit of copyright, lays no foundation for an exclusive claim to the art itself. The object of the one is explanation, the object of the other is use, and the former may be secured by copyright. The latter can only be secured if it can be secured at all by the latter's patent. So the application is for patent. The other one is the explanation can be secured by the copyright. So let's proceed to the issue of trademark infringement. This issue concerns the use of respondents of the mark poster ads, which petitioner president said was a contraction of the poster advertising. Pearl and Dean was able to secure a trademark certificate, but one where the goods specified were stationaries as letterheads, envelopes, calling cards, newsletter. Petitioners admitted it did not commercially engage in market these goods. On the contrary, it dealt with electrically operated backlit advertising units and the sale of advertising spaces thereon, which however were not at all specified in the trademark certificate. Under the circumstances, the Court of Appeals correctly cited Faberge Incorporated, an intermediate appellate court, where we, invoking Section 20 of the trademark law, ruled that the certificate of registration issued by the Director of Patents can confer the exclusive right to use its own symbol only to those goods specified in the certificate, subject to any conditions and limitations specified in the certificate. One who has adopted and used a trademark in his goods does not prevent the adoption and the use of same trademark by others for products which are of different description. Was correct and was in fact recently reiterated by Canon Kaboshki, Kaisha, and Court of Appeals. Assuming, for the sake of argument, assuming arguendo that the poster ads could validly qualify as a trademark, the failure of the Pearl and Dean to secure a trademark registration for the specific use of light boxes meant that there could not have been a trademark infringement, since registration was an essential element thereof. On the issue of unfair competition, if at all, the cause of action should have been for unfair competition, a situation which was possible even if Pearl and Dean had no registration. However, while the petitioner's complaint in the RTC also cited unfair competition, the trial court did not find private respondents liable. Therefore, petitioner did not appeal this particular point, hence it cannot now revive its claim for unfair competition. But even disregarding the procedural issues, we nevertheless cannot hold the respondents guilty of unfair competition. By the nature of things, there can be no unfair competition under the law on copyrights, although it's applicable to disputes over the use of trademarks. Copyrights gani, there are no issues on unfair competition, only on trademarks. Even a name or a phrase incapable of appropriation as a trademark or a trade name may, by long and exclusive use by business, such that the name of the phrase becomes associated with the business or product in the mind of the purchasing public. For instance, when we say toothpaste, we usually think of Colgate. So that's why all toothpaste sometimes is already called Colgate. What if there's another company who will call other company as Coolgate, toothpaste? So that's a form of unfair competition. Be entitled to protection against unfair competition. In this case, there was no evidence of Pearl and Dean and the use of poster ads was distinctive or well known. As noted by the CA petitioner's expert witness himself, had testified that poster ads was too generic of a name, so it was difficult to identify with any of the company. Honestly speaking, this crucial admission by its own expert witness that poster ads could not be associated with Pearl and Dean showed that in the mind of the public, the goods and services carrying the trademark poster ads could not be distinguished from the goods and services of other entities. This fact also prevented the application of the doctrine of secondary meaning. So you cannot apply the doctrine of secondary meaning. Poster ads was generic and incapable of being used as a trademark because it was used in the field of poster advertising, the very business engaged in by the petitioner. Secondary meaning means that the word or phrase originally incapable of exclusive appropriation with reference to an article in the market, because it is geographically or otherwise descriptive, might nevertheless have been used for so long and so exclusively by one producer with reference to his article that in the trade, that the branch of the purchasing public, the word or phrase has come to mean that the article was his property. So the admission by the petitioner's own expert witness that he himself could not associate poster ads with petitioner Pearl and Dean because it was too generic definitely precluded the application of this exception. So having discussed the most important critical issues, we see no need to belabor the rest. All told, the court finds no reversible error committed by the Court of Appeals. So whatever the decision by the Court of Appeals, it is being supported by the Supreme Court when it reversed the Regional Trial Court of Makati City, wherefore the petition is hereby denied, and the decision of the Court of Appeals dated May 22, 2001 is hereby affirmed in tutu. So Pearl and Dean